Thank you, Acting Speaker. I rise today to contribute to the Workplace Injury Rehabilitation Compensation Amendment Arbitration Bill 2020. Firstly, I commend the contribution from members on this side of the House, in particular the member for Altona, who was the previous Minister for this legislation. This is an issue that is of immense importance to me. The role of a leader in the union movement, especially in ambulance and other emergency services, the number one priority is not negotiations on pay and conditions, it's the health and safety of your members. Victorian workers need to know that they are going to return to their families each night and know that their hard work that they have done not only helps others, but also benefits them and their family. When an injury at work occurs and has an effect on an employee's health, it is important that those employees get the help that they have earned and are entitled to. It is vital that our WorkCover scheme delivers support to help them recover and to return to work. In my previous role in the ambulance union and along with many other union leaders, we fought for many years that our members and Victoria's employees are safe at work. A big part of this is ensuring that accidents are prevented from occurring to begin with. However, workplace accidents do happen, and tens of thousands of Victorian workers are injured each year. When this does occur, we need to make sure that fair compensation is available and that injured workers can get the support that they need. The mission is to return injured workers back to work as soon as possible. This isn't just what they have earned by paying their taxes and working hard, but it's also a basic, humane thing to do. Whilst advocating for workers, I've seen on many occasions where disputes have occurred between injured workers and WorkSafe agents or self-insurers. This can be an incredibly stressful time for injured workers. We should not underestimate the mental health impacts that often follow on from workplace injuries. It is therefore vital that resolving these conflicts are not stressful and done in a timely manner, not only for fairness, but to limit the harm caused by a workplace injury. I'm very pleased to see that this bill seeks to introduce a new, inexpensive and timely path for resolution for injured workers. This is a commitment that the Andrews Labor government's made to improve the process around making a claim for compensation so it doesn't exacerbate a workplace injury. Once again, our government is delivering on our promises. I'll detail the claims process as it currently exists. An injured worker may make a claim to their employer. The employer can hold on to that claim for 10 days and then send it on to the insurance company. The insurance company has 28 days to either accept or reject the claim. During that period, an injured worker might be sent off for an independent medical assessment. I can assure you the insurance company will take the full 28 days before they make a decision. So that could mean up to that stage, it's 38 days already when someone's been injured and possibly off work and possibly not receiving any income and not having any medical treatment. If the claim's rejected, the injured worker has 60 days to apply to conciliation. And just because they apply within the 60 days, in Metro, it could take up to 8 to 10 weeks before a conciliation is held. And in rural Victoria, it's even worse, where it could take 10 to 14 weeks before a conciliation is held. And at those conciliation matters, generally speaking, there's two issues, or two outcomes. It's either resolved by agreement or a genuine dispute. And a genuine dispute certificate would be issued if there's no resolution to the dispute. That injured worker can then go off and seek legal advice and make an application to the magistrates or Supreme Court. Now this could be for a process of a claim that has not been accepted. So we can have an injured worker off work with an injury, no medical treatment, no wages, for at least 6 months before that dispute could be forwarded on to the court. It could take up to 6 months before it would get to court. And I've experienced on many occasions when matters have been listed for the court that an insurance company has dragged it out till either the day of the hearing or the day before when they try and resolve the matter by making really an unsubstantial offer to the injured worker. It's atrocious the way some of these insurance companies treat injured workers. The aim is to have any disputes resolved in a non-adversarial manner. Of course, not all disputes will be resolved with this process, and the next step would be to proceed to court. This is my experience is where there can be some real injustices for injured workers. The lead speaker for the opposition, the member for Eildon, said injured workers may be reluctant to go to an arbitration. Well, I had many members that would have preferred their disputes arbitrated, rather than wait for a lengthy period of time before the matter was heard before a court or before an unscrupulous insurance company dragged it out to that time frame and then tried to settle the matter the day before. It is well known that court proceedings can take time. They can also be stressful and intimidating to those who are unfamiliar with the processes and the complexities of our court systems. If injured workers give up on their claims due to this complexity, then we are failing our workers, and there are many that give up. These big insurance companies wear people down. It's part of their practices. This is also a very clear position in the process that serious mental health stress can begin to impact on an injured worker, sometimes adding mental health concerns on top of the physical injuries that they may have sustained. The Victorian Ombudsman observed this in its 2019 report, WorkSafe 2, follow-up investigation into the management of complex workers' compensation claims. In response to this report, this government seeks to improve the dispute resolution process with this bill. One of the priorities that this government has is to give Victorian workers fairness and respect in their employment. These amendments places an injured worker in the centre of the decision-making process and lets them have a say how their dispute is handled. It contains an arbitration process that is aimed at lower-cost disputes, providing a choice for an injured worker to more quickly resolve a dispute about their WorkCover claim. If the parties to a dispute don't reach agreement and conciliation has not been successful, the types of matters that may be heard at arbitration include disputes about compensation for medical and like expenses and compensation for lost earnings. Injured workers will be eligible to receive compensation for medical and like expenses up to a maximum of $20,000 and lost earnings in the form of weekly payments for up to 52 weeks in duration. Most unresolved disputes are likely to fall within these thresholds, but these changes do not limit access to justice, and injured workers can still choose to instead to proceed to court if their dispute involves higher value. The provisions will operate prospectively, with the new model being made available to workers whose injuries are sustained from the date that the Act commences operation. Another key focus of these amendments relates to having timely resolutions. It should, of course, be a high priority to ensure injured workers can focus on their recovery and getting better to be able to return to work. Their time should not have to focus on fighting for their treatment and recovery. Injury should not drag out because of a long, drawn-out process. Everyone is a loser in such circumstances. These amendments seek to change the process. Once an application for arbitration is received, a hearing must commence within 30 days and conclude within 60 days of the first hearing date, and also be determined within 14 days of the final hearing day. This results in a timeline for disputes to be resolved within 4 months, which is less time than it takes to resolve most court proceedings. So, as well as providing injured workers with an alternative dispute resolution pathway, helping them to resolve the dispute sooner, these new laws will also free up court capacity by diverting claims away from the court system. And I think this is a really important part of this legislation. The time I have personally spent in court with lawyers from our union fighting for my members is immense. Freeing up our courts is a fantastic outcome of these amendments. One of my concerns, of course, that injured workers in these situations quite often have to represent themselves in this process. My members were always represented by the union or Union Assist from Victorian Trades Hall. I want to thank Union Assist for all their work assisting injured workers, and insurance agents representatives has extensive experience in these kinds of disputes. This could automatically create a power imbalance. I just want to pick up on a few comments that the member from Ovens Valley said on injured workers, that they can bypass the employer with their claims and direct the claim to the insurer, where the insurer has paid out a claim without the employer knowing. It just doesn't happen. So I don't know what the member for Ovens Valley was talking about. Yeah, Ovens Valley, yeah. What he was talking about, because it just doesn't happen. The insurer would make contact with the employer. And if they didn't, well, if I was the employer, I'd be getting rid of the insurance company. He also said that some claims or injuries did not happen at work under the Act, and that work has only What he has to understand is that work only has to be a contributing factor, such as a cardiac condition. So you could work in a stressful workplace that's caused some cardiac condition. I'm delighted we are achieving these reforms, and I commend the bill to the House.